Thomas Tice, here is the answer to your question that you emailed, coming right from Doug Allen.
Well, I appreciate that you thought this was an amazing interview. Let's see. If a union, let's see, such a lockout is determined. Well, here's the problem. First of all, the lockout wasn't determined to be illegal. The judge said it was, and then she enjoined it, but she stayed that injunction until it could be appealed to the appeals court, and they decided that the injunction was improperly granted and vacated it. So there was no injunction against the lockout. But that didn't mean that ultimately it wouldn't be found to be illegal. That just meant they weren't willing to prohibit it in advance of a trial. At a trial, it is entirely possible, in fact I think likely, that the lockout would have been found to be illegal, and so would anything like the draft or restrictions on free agency or a salary cap. But it would have had to go to a trial to prove that. And the problem with what you said in the question is that the owners, let's say it had been declared illegal, or later on a trial said that it was illegal. The owners would have to pay attention to that because they're not a single entity. They're not one business. They're a group of independent economic entities. Even though they work together in a league on things like scheduling, they're not allowed to collude on things like player salaries. They can only do that in an agreement with a union. And if there's no union, at some point, and the courts haven't said how long or when, or under what circumstances, but at some point they can't do it anymore. But if they agree to do it with the union, things like the draft, the standard player contract, the salary cap, restrictions on free agency, if they do it with the union, then it can't be challenged under the antitrust laws until there is no union. And that's the whole point of decertification, because when the union becomes something that protects the owners better than the players, then the players are entitled to and have said we don't want to have that happen. Now the organization doesn't go away. It just renounces collective bargaining rights. It renounces its right and its obligation to represent the players in collective bargaining. So they can still have an organization. It becomes essentially an advocacy organization, and it, in the last two times as this happened in the NFL, it pays for the lawsuit. But the lawsuit is on behalf of either all of the players or individual players, depending on which one you're talking about. It's not on behalf of the union. The union isn't suing anybody in the Brady case or in the McNeil case. The players are. The union is an organization that raises money to help pay for the lawsuit. So I think that answers the question. If it doesn't, email Amy and I'll be glad to add to it.
Thanks.